Start. Para. By invoking the provisions of Section 34 of the Arbitration and Conciliation Act 1996, the applicant has rushed to this court with a prayer to quash and set aside the arbitral award passed by the learned arbitrator in Appeal Number 213/2018 dated 4th March 2022. The land admeasuring 3,107 square meters bearing gut number 174 situated at village Phulgaon, Taluka Bhusawal, district Jalgaon was owned and possessed by the applicant. The said land was notified for compulsory acquisition for widening of the National Highway number 6 as per the National Highways Act 1956. The competent authority (land acquisition) National Highway number 6 and Special Land Acquisition Officer Jalgaon, that is opponent number 1, was entrusted with the task of fixing compensation as per the provisions of the said act. Accordingly, opponent number 1 declared the award void SR number 9/2011 dated 14/6/2013. Thereafter, as soon as the applicant got the knowledge about the appointment of the district collector Jalgaon as arbitrator, he approached the learned arbitrator by moving an application under Section 3(g) of the National Highways Act 1956 for determination of compensation void Appeal Number 213/2018 para. In Appeal Number 213/2018, opponents had raised question of limitation, stating therein that the application under Section 3(g) was barred by limitation. Applicant had vehemently opposed the contentions raised on behalf of the opponents. It was contended that the provisions of Section 2(4) of the Arbitration and Conciliation Act 1996 put a bar to the applicability of Section 43 of the said Act to the statutory arbitrations. Therefore, provisions of the Limitation Act 1963 are not applicable to the statutory arbitration emanating from Section 3(g) of the National Highways Act 1956. However, the learned arbitrator has, in absence of proper consideration of the averments made in the petition, rejected the application filed under Section 3(g) of the National Highways Act on the ground of limitation, though liberty is granted to file fresh application subject to the decision of the Honorable Supreme Court in SLP (Civil) Diary number 41922/2019, SLP (Civil) Diary number 36315/2018 and SLP (Civil) Diary number 1880/2019 para. Being aggrieved and dissatisfied with the aforesaid decision of the learned arbitrator in Appeal Number 213/2018 dated 4th March 2022, applicant has filed the present petition under Section 34 of the Arbitration and Conciliation Act 1996, read with Section 3(g)(6) of the National Highways Act 1956 for setting aside the impugned arbitral award passed by the learned arbitrator on the grounds set out in the present petition. Per contra, opponent number 1, void its say (Exhibit 11) has denied the contentions raised by the applicant in the application. It has objected the petition on the grounds that learned arbitrator has rejected the application on 4/3/2022 at the stage of admission on the ground of applicability of Limitation Act to arbitration proceeding under Section 3G (5) of the National Highways Act 1956. Opponent number 2, void its say (Exhibit 12), also resisted the application. It is contended that the learned arbitrator has rightly rejected the appeal filed by the applicant on the ground of limitation. The order of the learned arbitrator is reasoned 1. With regard to the contention of applicant that he was not informed about the appointment of arbitrator, it is contended that there is no provision under law to give individual notice to a land lodger. It is next contended that the provisions of the Land Acquisition Act 1894 are not applicable, as the land acquisition proceedings are governed by the National Highways Act 1956. Stop.